Welcome to the court-ordered meeting between Tangerine Life Insurance and the holders of its fully paid ordinary shares. Company Secretary, do we have quorum? Distinguished ladies and gentlemen, it is a great pleasure that I welcome you to the court-ordered meeting of our company, Tangerine Life Insurance Limited, also known as Tangerine Life. The company secretary has advised me that in accordance with Article 19 of the company's Articles of Association, a quorum has been formed. This meeting has hereby been duly convened and properly constituted. Accordingly, I hereby declare the meeting open. Before we start the business of the meeting, I would like to state the protocols for this meeting. Please note, for the participants via the online platform, all microphones will be automatically muted throughout the duration of the meeting, except when you have been granted permissions to speak. You may request permission to ask questions during question and answer session by clicking the raise your hand icon on the streaming platform. Your name once you are called upon to speak. You can also type in your questions in the Q&A window, which can be accessed via the Q&A icon. For those present in the room, you may indicate your intention to speak by raising your hand. For the introductions, I would like to formally introduce the board of directors of your company. As you are aware, my name is Ehimari Erikidiahi, the chairman of your company. Pursuant to the court order convening this meeting, I have been appointed to act as chairman of the meeting. The names being shown, other directors. Okay. I would like to introduce Mr. Livingston Magorimbo, the Chief Executive MD of the company, Mr. Ibitunde Balogun, an Executive Director of the company. I am pleased to introduce Mrs. Anne Agbo from DCSL Corporate Services, our company secretary. Due to the travel restrictions occasioned by COVID-19 pandemic, the following directors are not able to attend the meeting physically, but have joined the meeting virtually with our shareholders on the streaming platform. Mr. Charles Egan, Ms. Beatrice Ofer, Mr. Percy Eduardo, Mr. Olusheye Olushoga, Mrs. Marjorie Nwenge, a director of the company also. I would please like to introduce various professional parties who are advising us and assisting our company in taking various steps necessary to implement the scheme of merger. Stanbic IBTC Capital Limited, the financial advisors. Odo Odoma and Bello Sage, the legal advisor. Anison Tax LP, the tax advisor. Deloitte & Touche, as scrutineer. I would also like to acknowledge the presence of Mr. Gaba Kabiru, a representative of the Securities and Exchange Commission, who is in attendance in this meeting. The Corporate Affairs Commission and the National Insurance Commission were also invited to this meeting. Please note that voting on the resolutions to be moved at this meeting will be by poll, which means that every shareholder voting in person or by proxy shall be entitled to one vote for every share he or she holds. Distinguished ladies and gentlemen, this meeting has been conveyed pursuant to an order of the Federal High Court granted on 11th November 2020 to enable shareholders of Tangerine Life to consider proposed scheme of merger. The court directing that this meeting be held as well as the notice of the COM have been made available to you. With our kind permission, it will be taken as read. Distinguished ladies and gentlemen, I'm currently holding a copy of the scheme document which you have received prior to this court-ordered meeting. Pages 27 to 23 of the scheme document contains scheme of merger referred to in the notice of this meeting. So, all check. The scheme document to which I refer for most of today's meeting contains the following: an exemplary statement to you from the financial advisor to your company specifying the terms, reasons for, and effect of the scheme of merger. This can be found in pages 15 to 21. The fairness opinion reports on pages 17 to 20. The scheme of merger pages on 23 to 26. Appendix 2 on pages 37 to 44, which provides information on the company, and Appendix 3 on page 45, which provides further information on ARM Life.
The scheme document, together with the proxy forms for use at this meeting, were dispatched to members of the company. The notice of the court-ordered meeting was also published in newspapers. With your kind permission, the document will be taken as read. As you should have seen from the notice convening this meeting, the purpose of the meeting is to consider, and if thought fit, approve, with or without a modification, a proposed scheme of merger pursuant to Section 711 of the Companies and Allied Matters Act 2020.
Ladies and gentlemen, following the announcement of the scheme, Tangerine Life received feedback from shareholders of ARM Life on the scheme consideration. On the basis of the feedback received, the board of Tangerine Life has proposed that the cash consideration be paid to ARM Life shareholders be increased to 75 kobo for every scheme share, while any ARM Life shareholder electing to receive the share option will receive 8 Tangerine Life shares for every 100 scheme shares. The legal advisor will proceed to amend the scheme consideration in the sub-resolutions to reflect this. The resolution to increase scheme consideration will now be tabled for your approval, and if thought fit, passed as a special resolution with the rest of the subjoined resolutions.
The resolutions to be considered, and if thought fit, passed by a 75% majority of the shareholders of the company that are present and voting in person or by proxy at this court-ordered meeting are: 1. An amended subjoined resolution 1 as follows. Subject to the increase of the cash consideration from 70 kobo to 75 kobo, the scheme document dated 6th November 2020, a printed copy of which has been circulated to the shareholders of the company ahead of this meeting, and for which, for the purposes of identification, has been endorsed by the chairman, be and is hereby approved, and that the directors of the company be and are hereby authorized to consent to any modification of the scheme that the Securities and Exchange Commission or the court shall deem fit to impose and approve. A revised subjoined resolution 2A as follows. The amount of the cash consideration which is to be paid to each ARM Life shareholder be increased from 70 to 75 kobo for every scheme share, while any ARM Life shareholder electing to receive the share option who would receive 8 Tangerine Life shares for every 100 scheme shares, and accordingly, all references in the scheme document and ancillary documents in respect of the scheme to the cash consideration to be paid to the holders of the scheme shares be deemed to have been changed from 70 kobo to 75 kobo.
I hereby request that someone move a motion for the resolutions just read by the company secretary to be approved, and that they be passed with the rest of the subjoined resolutions, and in replacement of the subjoined of the sub-resolutions 1 and 2A. Would someone please move the motion?
Mr. Chairman, my name is Dikpo Okuribido, representing Lawyers Limited. I hereby move this motion.
Would someone please second the motion? My name is Eric Idiahi. It gives me great pleasure to second the motion. Ladies and gentlemen, the subjoined resolutions to be tabled for your approval will now be read by our company secretary.
Thank you, Mr. Chairman. Voting on the resolution will be by poll, which means that every shareholder voting in person or by proxy shall be entitled to one vote for every share that he or she holds. The statutory majority required to approve the scheme is a majority representing not less than 3/4 in value of the shares of members present and voting either in person or by proxy at this meeting. The subjoined resolutions to be considered and if thought fit passed as a special resolution are contained in the notice of the meeting on pages 53 to 55 of the scheme document. I will now read the subjoined resolutions for consideration. That, 1, subject to the increase of the cash consideration from 70 kobo to 75 kobo, the scheme document dated 6th November 2020, a printed copy of which has been circulated to the shareholders of the company ahead of the meeting, and which for the purposes of identification has been endorsed by the chairman, be and is hereby approved, and that the directors of the company be and are hereby authorized to consent to any modification of the scheme that the Securities and Exchange Commission or the court shall deem fit to impose and approve. For the purpose of giving effect to the scheme with or subject to such modification, addition, and condition agreed between the company and holders of its ordinary shares and or approved or imposed by the court. The amount of the cash consideration which is to be paid to each ARM Life shareholder be increased from 70 kobo to 75 kobo for every scheme share, while any ARM Life shareholder electing to receive the share option who will receive 8 Tangerine Life shares for every 100 scheme shares. And accordingly, all references in the scheme document and ancillary documents in respect of the scheme to the cash consideration to be paid to the holders of the scheme shares be deemed to have been changed from 70 kobo to 75 kobo. In consideration of the settlement of the scheme consideration by the company to ARM Life shareholders, the company be and is hereby authorized to enter into a merger and business consolidation with ARM Life such that, upon an order of the court, all current assets, non-current assets, current liabilities on the statement of financial position of ARM Life as at the effective date shall be transferred to the opening post-scheme statement of financial position of the company without further act or deed by the parties. All employees and undertakings, including but not limited to real property, intellectual property rights, permits, credits, allowances, equipment and machinery, plant, fixtures and fittings, motor vehicles and businesses. Also, rights, powers, and duties of a personal character which could not generally be assigned or performed vicariously of ARM Life shall be transferred to the company without further act or deed by the parties. All legal proceedings, claims, and litigations pending or contemplated by or against ARM Life be continued by or against the company. The entire share capital of ARM Life shall be cancelled and ARM Life shall be dissolved without being wound up. All contracts of ARM Life shall not be terminated or have their terms materially or adversely changed by the scheme, but shall continue to be in force and effect and be implemented by the company. All monies standing to the credit of ARM Life at banks and with other debtors within and outside Nigeria be held to the credit of the company. And the board of directors and the company secretary of the company be authorized to do all such things and take all such actions as are required to give effect to the scheme.
I hereby move the motion that the subjoined resolution just read by the company secretary and stated in the notice on pages 53 to 55 of the scheme document be approved. Would someone second the motion?
Mr. Chairman, my name is Diko Okuribido. It gives me great pleasure to second this motion.
I now put the motion to the meeting and asks all shareholders to vote either in favor or against or abstain. Vote for. I hereby direct that a poll on the motion before the meeting be taken forthwith. I will now invite the company secretary to explain the voting procedures. Ladies and gentlemen, I will now ask you to wait patiently while the scrutineers collect the results of the polls. Okay. Ladies and gentlemen, I will now announce to you the results of the poll for the subjoined resolution. The total number of shares held by the shareholders present who voted either in person or by proxy on the resolution is 1,724,681,012. The total number of shares voted in favor of the resolution approving the scheme is 724,681,012. This represents 100% in value of the shares held by shareholders present and voting in person or by proxy. Based on the results of the poll, I declare the motion unanimously carried. The report of the results of the meeting will be filed with the Securities and Exchange Commission for its final approval. Following the grant of the final approval by the SEC, a copy of the results will also be submitted to the Federal High Courts to enable it to sanction the scheme of merger so that it may become effective. Ladies and gentlemen, the announcement of the results has brought us to the conclusion of the business of the court-ordered meeting. A copy of the voting results and shareholders' resolution will be submitted to the Federal High Court to enable it to provide an order sanctioning the scheme. I thank you all on behalf of the Board of Directors of Tangerine Life for taking the time to attend this meeting, and I now declare this meeting closed.